Welcome everybody, good afternoon. Welcome to this webinar about creativity and IP. My name is Carmen Casteras. I will be your trainer this afternoon. I'm a lawyer at the company KIM, Knowledge Innovation Market. KIM helps the companies to innovate and to design business models for commercializing their innovations. What's the point of me being here? Well, I'm a lawyer specialized in IP for 14 years, and as I see it, IP is a business asset to play with and win. It keeps competition at bay and serves your business model to increase ROI. ROI, I mean return on investment. As you know, companies cannot compete anymore on price, and believe it or not, copy is lawful. Yes, it's lawful. Surprisingly, copy is lawful unless you protect your creations and inventions. In case you would have a good or a bad experience with IP issues, please don't hesitate to share them with us. KIM belongs to the Knowledge Agents Alliance, which is the combination, the sum of 3 Spanish entities supporting large enterprises, small and medium companies, RTOs, investors, and governments. We help all these agents to improve the return on R&D investments. How we do this? We help innovating, we help landing those innovations, those business opportunities, and turning them into feasible business models by protecting them, by acquiring more technologies, and we also help commercializing technologies of the companies. So we help to validate the business models and generate revenue. Let's start. Firstly, please have a look at the difference between the concept authorship and ownership. Authorship means, well, it's me, I'm the author of these slides. And what's protected by copyright here is the script, it's my talk, and the illustrations. Please take into account that copyright does not protect the underlying idea of talking about the most common IPRs for creative industries. Copyright only protects the way, the expression of this underlying idea. And regarding the ownership, you will see that it's not mine slides. The ownership belongs to my company, Knowledge Innovation Market. I don't have the economic rights thereof. And why? Because I'm an employee of KIM under labor contract, and one of my job responsibilities is to prepare these slides and to work as an IP manager at KIM. Copyright law establishes that the ownership is from the employer under these kind of circumstances. Secondly, please take into account that the webinar is being recorded and that it may be disseminated to a wide public by any possible means. And also, please take into account that the training material concerns IP strategies only in general terms. This training material should not be relied upon when taking specific business or legal decisions in a specific country, because IPRs are territorial rights governed by the laws of each country. So rather, professional advice should be obtained which suits the circumstances and country in question. Before starting, here you are the rules of participation. You will be in listen-only mode to avoid sound issues. If you wish to formulate a question, just click on the raise hand icon and we will open your micro. You can also use the chat windows on your left hand to send your questions. At the end of the talk, we will have time for Q&A. We will have like 20 minutes time. Nevertheless, please, you can stop me if you don't understand something. I would like to do the webinar interactive, if possible. I've divided my talk into two main points. Firstly, we will have a look at the most common IPRs in the creative industries. Secondly, we will talk about IP management and exploitation, that is, how to turn creativity into business assets. Then we will solve and discuss all together an exercise just to put the foregoing into practice. And finally, I will open the Q&A session. My talk will last for more or less half an hour, and the Q&A session will last more or less 20 minutes. So by 6, you are free. Okay. Our learning objectives of this afternoon is understanding that IP is also for creative industries, understanding what an IP strategy is and how it influences return on investment, and understanding that IP strategy should be integrated within the overall business model. Let's start. Which intangible assets do companies have? Anybody knows? Anybody would be able to send a reply? No? Okay. Could they be technical innovations? Could they be better processes? Could they be aesthetic innovation, marketing strategies, creation of the mind, employees, with the competitors? All these kind of assets are intangible assets that you have to turn into IP rights, to turn them into business assets to play with. These are the most important intangible assets that are very easily protectable by IP. We have technical innovation, not necessarily technological breakthroughs, but maybe just a better process. We have aesthetic innovations, not necessarily art, or something very, very original and very creative, but just a new combination of colors or just a new shape of packaging. Signs that are distinctive and that serve you to identify your goods and services from the ones of your competitors. Creations of the mind, such as these slides, such as a computer program, an original database, a map, a plan, book, poetry, etc. And confidential information which has value for your company. It could be technical value or it could be commercial value. These intangible assets are protected under patent, trademark, and copyright laws. For instance, patent and utility models cover technical inventions. Designs cover aesthetic, non-functional creations applied in the industry. Trademarks cover distinctive signs to identify the goods and services of your company. Copyright covers the creations of the mind. And contracts, this is also very important, cover trade secrets, cover this confidential information that you want to keep secret. Which kind of contracts? Well, you have the non-disclosure agreements, you have the employment contracts, you have the non-competence contracts, you have the non-solicitation, non-solicitation contracts, no hiring, governance, etc. And what does IP confer us on? What do you think? IP grants us a legal monopoly with an owner in a territory for a period. The period, it may be 20 years in case of patents, or it may be forever as long as you renew a trademark every 2 years. Or it may be the lifelong, the life of the author lasts 70 years. IP is territorial, so the concept of territory is very important. You have to have a very clear business model just to know where to apply for your IPRs. You have to know where you are going to export, where you're going to manufacture, where you're going to commercialize, because there are the territories you should cover your patent, trademark, design, copyrights. If your business model is not only direct, but is also indirect, I mean, if your business model is to grant a license to a third party, you need to know where the third party is going to manufacture and commercialize, because you should cover all their territories. You should know where your client, where your licensee is going to lead them. Secondly, IP can be economically valued. This is very important. Economic value is when licensing or assigning a patent, trademark, design, or copyrights. When evaluating, you get a prize. You improve also your accounting and finance. You may also get a tax incentive. Have you heard about patent box, for instance? It's a tax incentive that you should know. Okay. In copyright, it's not protected, it's not covered by patent box, but the trade secrets and the concept related, for instance, to the software could be covered by patent box. Okay, if you have any further questions about all what IP confer us on, you can just email me. To conclude this slide, IP portfolio attracts partners, opens markets, and helps diversification. So, how does IP work? IP work confers intangible assets, private and marketable. IP provides the owner the right to prohibit others from using his creative work and innovation for commercial purposes. So IP is a negative right. It does not grant you the right to do anything, but it gives you the right to prohibit others doing something. Okay? IP grants exclusive rights. And what for? Well, we have a strong position. If we have IP, we have competitive advantage, we have the first mover advantage. We can get additional income by assignment or license of IP. IP helps us exporting, franchising, so it helps us to increase the return on investment. This goes together with cross-licensing, because if we have a problem with a competitor, that the competitor is accusing us of infringement of their copyrights or the patents, we can cross-license. We can give the competitor a license also of our IP, and we can share. IP is also very important if we want to raise money. As you know, bank financing and investors normally they require due diligence in IP. And IP portfolios are very good criterion to grant bank financing or investment. And we also gain a positive image, marketing one. Here you are. This is the concept of open innovation. Just imagine that you have that this orange is knowledge. It doesn't matter if it's aesthetical invention or aesthetical innovation, excuse me, or an invention or a copyright or a software or whatever. That you have a knowledge here, and this knowledge allows you to get to your current market. This is a direct exploitation of your knowledge. That's perfect, but you can improve this. You can add knowledge belonging to third parties through in-licensing, and you can also evaluate if your knowledge can be also partly out-licensed to a third party. And so you may get to another market. I don't mean to open for markets. This would be crazy. I'm just saying that you keep your current market, but that you can obtain extra revenues from other markets through in-licensing and out-licensing. That is through a good management and exploitation of your IP, because this orange will be protected either by copyrights or patents or trademarks or designs, and all these IP rights may be licensed. Any questions so far? Are you with me? Okay, continue. Let's have a look at the most relevant IPRs for the creative industries. We have copyright, which protects literary, artistic, scientific, and related works. We have trademarks, which help us identifying our goods and services in the market.
Excuse me, Carmen, there is a question.
Which protects the appearance.
Carmen, sorry, there is a question.
Yeah.
Ruth wants to make a question. Ruth, I had opened your mic. Sorry, she just raised her hand, but she's not online anymore. Okay, sorry.
Yeah, should I continue?
Yes, please. Thank you.
Okay, I continue. We have also trade secrets, know-how and confidentiality, which protect the secret valuable information. And we have patents and utility models, which protect a technical solution, which has novelty, inventive step, and industrial applicability. Normally, the creative industries think that they don't use patents, but this isn't correct, because software sometimes you can have also computer implemented inventions which are protected by patents. So don't disregard patents before studying it case by case. Well, copyrights, original works fixed in any tangible medium of expression. Two words here are very important. Originality, that means that it's independently created, that it's not copied. And fixed, that means that it's not the idea itself, but it's the expression of an idea, the expression of a creation. Okay, it has to be supported, or recorded, or written down, whatever, but it has to be fixed in any medium. Most relevant works protected by copyright to small and medium companies normally are computer programs, databases, websites, reports, training materials, dissemination materials like leaflets, etc. Copyright is for free. I mean, neither publication nor registration are necessary for copyright protection. Nevertheless, it's very advisable to place this, okay? Just to place the C and indicate the owner and the year of publication. Just to communicate to to the world that this work is protected by copyright. And for free, it doesn't mean that it hasn't got any cost, because you should, when possible, you should try to apply for copyright or to go to the notary to have registration, not formal registration, but a kind of proof that it's yours. And what doesn't copyright protect? Copyright does not protect facts, ideas, concepts, systems, methods of operation themselves, only the way these things are expressed. It does not protect domain names, slogans. Who can claim copyright? The author of the work or the author's heirs or assignees. Very important, not the person who only owns the physical work itself. At business, it's the employer who may be the copyright owner of employees' works if employees create the works acting within the scope of their employment and the labor contract. That's the reason why I said before that these slides are mine, in the sense of I'm the author, but they don't belong to me, as in the sense of economic exploitation. They belong to my employer, which is Kim. So let's differentiate moral rights and economic rights. Moral rights is to say I'm the author, it's the paternity right, and the right to the integrity and the reputation of my creations. And economic rights are the most interesting ones. That's the right to use, to make reproductions, to distribute the works to the public, to do public communication, to transform, to do derivative works. I mean, for instance, to prepare a novel and convert it to a movie. That's a derivative work, and that belongs to the employer and not to the author. Well, this can be transferred to third parties. Okay, when we had this orange are only the economic rights and not the moral rights. Sorry. Well, and trademarks, they are also very important because they help us to construct our marketing strategy. Consumer loyalty towards our trademark renders us competitive. And trademarks make life easier to the consumer. They save him time. So we need to create a brand and then protect the brand as a trademark. What is a trademark from a legal point of view? It's a sign that helps to distinguish the goods and services of one organization from those of another. From a more practical point of view, it's a set of tangible and intangible attributes, rational or emotional ones, and it's an exclusive right obtained by registration. Only if you have a very well-known trademark, you cannot register it because the use would be sufficient. But please register your trademarks because it would make your life easier. What for? To identify the origin of goods and services, to guarantee consistent quality, to serve as basis for publicity and advertising. Very important to bring value to the company as a business asset, since it helps your franchising, exporting, transfer, and collateral, so bank financing. And to prohibit its use by third parties, so it keeps competition at bay. Types of marks. Here you can see word marks, mixed, word plus logo, graphics, three-dimensional. These are not the trademarks themselves because the three-dimensional are without the names, are only the shape of the chocolate and the granini battle, but without the label. Three-dimensional means that only the shapes of the products have become so distinctive that they are able to indicate the origin of the goods. So they are able to become a trademark and not just a design. We can apply also for sound as a trademark or for a smell, which is very interesting. We can apply also for a color, as the lila from Milka, or an animated trademark. Are you following me? Any questions? Okay, I continue. What's an industrial design? It's the appearance of the whole or part of a product resulting from the special features, including contours, color, shape, texture, materials of the product itself, or its ornamentation. Important, no technical or functional features. If we have technical features, no problem, but we would apply for two different types of rights. We would apply for a design and also for a pattern or a utility model. You can also combine IP rights. The requirements to be met by industrial designs are novelty, visible, original. Original is as copyright is not a copy or imitation of other designs. And individual character, which means only that it must produce on the informed user a different overall impression from the other designs. Patents. The most important question, will the patent be useful to my business strategy? Because if not, forget about it. A patent gives the patent holder the right to prohibit others to use, produce, sell, store products, or to use methods claimed in a granted patent. It's a legal document that creates property, and patents are territorial rights. Most important concept here, the right to prohibit others. A patent does not confer us the right to do anything. We could have a patent and we maybe don't have freedom to operate. Okay, let's differentiate the patent from the product. When we have a product, we have to see which possible IP rights cover the product and that we don't infringe any other IP very similar to our product. Well, the requirements of the invention to be patented. First of all, it has to be technical. A technical solution to a technical problem, so it has to be an invention. Secondly, new. New is new to the world. That's not included in the state-of-the-art. And state-of-the-art is everything that is accessible to the public, written or oral disclosure. Thirdly, inventive, which means that it does not derive from the state-of-the-art in an obvious way. It has to have industrial application, and it has to be sufficiently described so that an expert on the subject could carry out the invention. And finally, we have the trade secrets, which are very interesting for the creative industries. Trade secrets are know-how, which is confidential information. Secret, of course. Substantial, identified, that means that information is written down or on a support material, but it has to be identified. And valuable, which means that the information has a monetary value for use or exchange. Very important. Trade secrets are only protected if your company has taken what is called reasonable steps to keep the information confidential. Such steps include locking doors, using passwords, placing appropriate confidentiality blocks on documents, clean desk policies, employee badge policies, and agreements such as employment agreements, NDAs, I mean non-disclosure agreements, non-competition agreements, non-solicitation agreements, no higher governance. And to conclude, we can say that trade secrets are protected under unfair competition law. Let's move to IP strategy. How do we turn creativity into business assets? Well, we have to combine and to know a lot about all these IPRs. First step, we have to identify the knowledge that you can turn into a business asset. And it's the knowledge that allows you to influence on the behavior of your clients, your colleagues, investors, your competitors, your public administration, etc. What allows you to influence on the behavior of others? Is it a technical knowledge? Is it aesthetical innovation, original works? Maybe intimate knowledge about your clients. Then you have to identify the rules that govern each kind of innovation and each kind of knowledge. Is it copyright? Is it a creation of the mind? Or is it industrial property in the sense that it's applied in the industry and then it could be a patent, a trademark, a design? Or is it a trade secret and then the rules is oriented to keep it secret? And then you have to know about IP strategy. So we have, let's sum up a bit. We have to identify what we have in our companies. We have to valorize them by knowing how it could be protected. And we have to put the correct questions to commercialize them. Commercialize in a wide sense. I mean, it's not necessary to commercialize them, but to exploit them in an economic way. And the most interesting questions could be, do they belong to me? Maybe I'm not the author, but I'm the employer. Are they worth protecting them by IPR? And if I say yes, why? I mean, will they serve my business model? Because the protection itself, it doesn't serve anything. The protection has to serve a business model. Will I be ready to fight against infringement? Will I be ready sometimes means, will I have the money to fight against infringement? How should I protect them? Where do I have freedom to operate? When should I file the application for the IPRs? One means that in the case of copyright, it's very easy because it's from the moment that you create the work. But for a patent, for instance, if you file a patent today, you only have 1 year to decide where to go. And in 1 year, you have to take this decision, and you have to have the budget to support this decision. Okay, so when is very linked to budget. And the last question could be, am I solving the needs of my client? And with client, I mean these, the 4 markets are my client. I have my current client, and I have to protect the IP rights in my market because they are my current client. This is my market, but I also have to take into account that if I can open a third market, I need to know where it is, and if I'm opening a 4th market, I need to know what he needs. These are my markets. Okay. So let's see some examples now. Are you with me? Are you following me? Could you raise a hand just to know, just say me we are here? Okay. Let's discuss some IP strategies. For instance, if you were the CEO of a small, medium enterprise that develops and sells computer programs, what should I take into account? Could you write an answer for me, please? What do I have if I develop a computer program? Not me as an author, but if I'm the CEO of a company that develops and sells computer programs or other copyrights, what should I take into account? What do I have? Okay, I will reply. Okay, I have copyright, of course, on the software itself as such. I have copyright on the instructions manual. I would apply for and before disregarding the patent protection, I will have a look if my software could be the process of a more wide invention, which could be computer implemented invention, and that could be protected by patent. And I would apply for this patent. I would also apply for a trademark, and I will build a business model that could be me directly selling the computer program or making copies and selling them, or it could be also to license these copyrights and this trademark on the computer program and allow others to also make copies and sell them. Okay. Next example. If I were the CEO at an advertising agency, what would I have? I could have also trademark. I would have designs. I would have copyrights for sure. And I will decide also if I license some of my IP to third companies. It's not necessary to protect. For instance, the advertising agency could keep the copyrights because they belong to the agency, but it could authorize the company that paid for instance, this advertisement could let the company that paid for it to obtain a design or whatever, the IP right that would correspond. Okay. And also, if I worked for a designer brand, I would have copyrights, designs, and trademarks. If I were the owner of a coffee club, the same. The trademark could be very important, and it could be the way to open other coffee clubs with the same name. The trademark, in this case, would help me to construct a business model. And if I were the CEO of a company that produces a new kind of chocolate, well, then I would have the product itself, which could be a formula, which could be protected by patent. I would have the shape of the product that could be protected by design or by a three-dimensional trademark if it becomes very distinctive. I would have the trademark. I would have probably, depending on the kind of receipt, I would have also the option to keep it secret and protect it by trade secrets and then forget about the patent. Well, and then we start the exercise. I need your participation. You can read a small company that offers following services to their clients: graphic design, events, publications, online platforms for entrepreneurs, projects, websites, reports, layouts, multimedia presentations. And the company is small and it has only 3 employees, and when it needs it, he hires freelancers. What could be the IP strategy? What do you think? Anybody? Anybody? What do we have here? Which kind of intangible assets do we have that are protected by IPRs? Any questions? Did you follow the webinar? Okay, I'm here, I'm mobile. Okay, should I answer? Are you there? Okay, we have different intangible assets here. We have designs, we have protection on the photographs, We have protection on the scripts that maybe are used for the dissemination materials, for the posters, the leaflets. We have copyrights on the software when designing a platform, and we have copyright on the website, not only because of the software, but also the design, the distribution, the photos, the scripts. And we have, of course, protection for the multimedia presentations by copyright. It's very important, the word freelances, because that means that the ownership is not automatically granted to the employer. So this small company has to continually sign contracts with the freelancers for assignment of their IP rights to the small company. That's very important, because if not, the authorship as well as the ownership will belong to the freelancers. I will show you some keywords already discussed. Intangible assets, we have already seen this. Ownership of the works, very important. Business model, we have to decide if we are going to exploit these copyrights and industrial rights directly or via third parties. And very important, the contracts. Don't forget about the contracts with your employees and with third parties. And also with the clients, because normally the clients that, these are called commission works or hired works, and the authorship and the ownership continue belonging to the company that create them. So take into account that if the client does not propose to sign an assignment clause, you keep this ownership, okay? And you can decide if you are working with this client only for a very particular application of the work and not for others. I mean, if a client hires you to do a website, then the client cannot take some pictures or photos of the website and put them in their leaflets. They should pay you if he does this. Okay, here you have more keywords. Don't forget about the brands and protect them by trademarks. Don't forget about works and all that mean, and it's automatic protection by copyright. Always raise the question if you have an industrial design that could be protected. Also, if you have a technical solution that could be protected. If you have confidential information, take the steps appropriate to get this protection of trade secrets, which is very important because you also can license trade secrets and get income for this license. Don't forget about the domain name that helps together with the brand, helps your marketing strategy. Take into account that it's not the same freelancers than employees. If you work with freelancers, you need to sign an assignment of rights contract. If you work with employees and they are doing their work, you own the works by law. Remember transferring the economic rights for certain uses. And remember growing, and growing is going to be through your business model, and the business model will count a license of company's trademark to another small company in another country. This is all I wanted to share with you. this afternoon. I will open now the Q&A session. Okay, if you have any question, please, I'm at your entire disposal. Thank you very much for your attention and your time. Thank you.